much for attending. You know how we like to go every year. We appreciate you allowing us to do this remotely. It's a great event. We've got a nice, we're doing 2 hours this year. It's a pretty packed seminar. We'll take a break after 50 minutes and we'll pick up again, 10 minutes later, so that you guys get your full credits. We're going to cover, it's kind of a focus on CPAs in terms of practical issues you're going to encounter in your practice associated with asset protection. Really, what kind of business and personal structuring should people be doing day to day, and when are they exposed, usually for no reason. We're going to start with LLCs, and we'll kind of transition to trusts, because typically we use these two vehicles together, and that'll be the first hour. And the second, really 50 minutes, will be the taxation side, the foreign taxation, domestic taxation, trusts. We'll throw in some LLCs. I know you're already quite familiar with taxation of LLCs, and then we'll have some compliance. We'll have some conclude. We'll conclude and we'll go ahead and take any questions. I'm trying to get this thing so where it
Over there.
over here.
Yeah, there you go.
Oh,
Yeah,
okay.
there you go.
Oh, that's it. You just click it.
Yep.
Oh, okay. New format, new people. Yeah, new situation. There's the agenda, like I said. So we'll start with LLCs, we'll move to trusts, domestic and international, then we'll go to the tax side. For those, I know Matt's probably could give this part of this seminar, for those who are new to the area of law known as asset protection. It's not hiding assets. It's not running away from a creditor or trying to conceal something that's occurred, or where we place assets or how we own them. It's basically using existing legal structures such that on a clear day you can plan, and if later you run into litigation, you don't have to give up what you have. This is kind of an overview. It's got a little, Tony does these great little comics at the end and stuff. But a lot of people, when they boil it down, want to know, okay, well, what are corporations, for instance? Is that asset protection? Well, yeah, it is. I mean, that's what's been going on for the last 100 years. Basically, if you want to form a business, and you don't want to be liable for the liabilities, what happens inside the business. If there's an order or you're a manufacturer and you provide a widget and it doesn't work, you're not personally liable. There's exceptions to that for fraud and bad acting, but essentially that's really the basic form of asset protection. What we talk about in terms of these 4 things, titling, exemption, trusts, and entities, are just the 4 areas of asset protection. Titling, for instance, in Florida, you don't have a full tenancy by the entirety in New York. But titling, if we have a husband and wife and we title for instance, their bank account or their real estate together, and husband runs into problems, the property is not available. It's simply not available. You have to have a claim against both husband and wife with respect to property held by the entireties. And there's other titling that's somewhat protective, but titling is a factor. And a lot of times New Yorkers will, for instance, open an account in, let's say, Florida or Delaware. Well, there's a school of thought that says they can open that account by the entireties. So there's some asset protection, some kind of what they call poor man's asset protection to be done on securities accounts. Very, very few people in New York City understand that, but it really should be taken advantage of. The second area of asset protection are exempt assets, which everyone thinks of life insurance, for instance. So in Florida and New York, if you own a life insurance policy under certain circumstances, if someone sues you, they cannot reach the cash value of that policy. I like the New York statute actually better than the Florida statute. The Florida statute says if that the policy value is only protected against creditors of the insured, which is a kind of a stupid way to go about this, but I don't know, maybe the lobbyists got a hold. I actually don't know why this law came out like this. The lobbyists got a hold of it. So if we've got, because we're talking to CPAs and we've really customized this presentation to CPAs. If we're talking about CPAs, you come across a buy-sell agreement, right? First of all, if you have a buy-sell agreement, it's likely for a corporation, which they shouldn't be, and they probably should be an LLC. Secondly, they've got a buy-sell that's funded by insurance. And sometimes you'll do a cash value insurance for buy-sell. If you really want to make sure, you know, that there's money there if someone dies, you know, a spouse gets paid off and the surviving partner moves on with the business, you might have a valuable policy. There's so many policies now. It used to be like there was term, which expires, and you had a whole life where you essentially paid a cash value in, and it was like a savings mechanism. But now you have so many policies that can hold securities, that can be part term, part universal. A lot of times it has cash value. But if I own a policy on Brian, which I should buy, by the way, now it's reminding me of see, this should remind me, I should buy a policy on Brian. He's so valuable.
I'll pay you later. Thanks.
Well, I hope it's not in a bad way.
No.
You know what I'm saying? I hope it, maybe you should have one on me.
Maybe.
You know what I mean?
Maybe.
I could become a rich man.
Maybe.
The owner of the policy is not the insured. So if I'm sued, the cash value is not protected, because it's only protected against creditors of the insured. Anyway, this stuff becomes very technical. I think it's stupid that it's technical. I think it should be very simple, but they've just worked this out in such a way. New York, it's in my book, but I don't recall. I sent you some books. Matt's got some books. If you need a book, if you need another book and you're not on site, just email us. Our email will be at the end of the presentation, and I'll send you a book. No problem. We'll get a book on asset protection and a book on tax for the estate tax for the non-citizen. Anyway, New York, I recall having a little bit more clear statute. It was a little bit more practical. Anyway, these exemptions are very interesting. You don't have to have an LLC. You don't have to have it in a corporation. It's actually just exempt from creditors. In Florida, we have a homestead exemption. That's the only one of its kind where you actually can be sued and be running, to the court step, away from the creditor, from your judgment, and buy a house, and you get to keep the house. I know it sounds crazy, but it's actually true in Florida. I don't know if you've heard of that, but it's created some really dramatic little situations.
Like OJ, an example.
OJ never ran so fast.
Yeah,
I'm telling you, he never ran so fast. What was he, 50?
Yeah, something like that. Late 40s.
Still got into trouble afterward.
Yeah,
Still got into trouble.
It was safe, but they never got his house.
No, I'm sure they didn't. I'm sure they didn't get his house, actually. So the third section is trust. The third type of asset protection are trust. So classically, we put money into a trust for someone else since the 1500s in England. So husband goes off to war, he puts money in trust for his children, and he appoints a trustee. Maybe it's wife, maybe it's his buddy. What happened? When he went off to war, he split the title to the assets. Now, instead of just someone owning and using and benefiting from the assets, you have someone who controls the assets, the trustee, but does not benefit from the assets. It's like a contract. It's the job of the trustee to control the assets and preserve the assets for the benefit of the beneficiaries. The beneficiaries, the kids, don't control the assets, but benefit from them. And if the trustee has discretion on when to make a distribution, you've got complete division of title. So if the trust fund baby gets into trouble, there's nothing to get. There's nothing to get. It's an area of frustration of the courts. It does come up a lot. I've been involved in cases where the courts have essentially tried to do whatever they can to get to some of this money. It's very difficult to reach because the beneficiary does not have the legal authority to reach into the trust to get the trust assets, and the trustee says, I'm not making a distribution. There's nothing to get. That's a trust. We're going to go into some changes that have occurred with trust, but that's the third means, the third tool on asset protection. The fourth tool are entities, typically business entities, and it's really boiled down to the LLC, which was, I think we're going to have a slide on it actually. The corporation, here we go, yeah. Versus the LLC. So the corporation business entity says, well, I have mentioned if something happens in the business, the owners are not liable. The LLC takes it a step further. Okay, we mentioned veil piercing on here. For instance, in a corporation, if you want to sue the owner, you're piercing the corporate veil. You probably heard that term before. And what that means is either they've treated the corporation as kind of their personal piggy bank, or somehow they've used the entity for fraud, that this creditor of the business can reach out and pierce the corporate veil to get to the owner. So that's the inside asset protection. It's that the creditor inside cannot reach the owner outside. But the LLC offers outside asset protection as well. So partnerships, I know CPAs love partnerships, because once we have a handshake and we have business, we have a partnership, even if no articles are filed or anything. So everybody's liable in that one. Anything happens in the partnership, everyone's personally liable. But here's the thing. Although you're personally liable, which obviously you should never get involved with that. There's just no reason ever to do that. What developed in terms of the law is that if a partner is sued, that this outside claimant cannot take assets of the partnership. They can just get a lien. That's called a charging order. So the LLC combines this idea of someone, let's see here, yeah, of someone not being able to be reached based on business of the LLC. So if you do business, your only assets available to the person you're doing business with are the business assets, with the idea of outside protection, where if I'm sued as an individual, my equity in the LLC is not available. Here's how it developed. It's somewhat interesting in terms of the partnerships, because we went through a transition with partnerships where you had the traditional, I'm liable for everything that happens, but if I'm sued, you can't take my equity. And then you had limited partnerships where one of us is liable, the general partner, but the rest, we just put the money in, that's what's at risk. We went years with these limited partnerships. And I don't know if New York did this. I don't think New York did this, but I think 20 states put the L in front of the limited partnership, LLP, and put the L in front of, it's actually LL. So it's the LL in front of the partnership and LL in front of the limited partnership. Gets a little confusing. Fortunately, it's become completely irrelevant. So what that did is it eliminated the liability of the general partner. So what do we kind of have? We kind of have an LLC, right? So if we don't have any of the partners that are liable for the actions in the business, and you can't get to the equity, you kind of have an LLC. It didn't look like an LLC when you read it, but that's where they were going. Wyoming then started the first LLC, and everyone kind of followed suit because it's this hybrid entity. That's the word, right? Hybrid entity where you have the advantages of both a corporation inside, and you have the advantage of a partnership where no one theoretically can get equity in the LLC. It's also a little bit more straightforward. There's no annual minutes. The procedural requirements are relaxed. A couple of items on the slide. I'll tell you what the hard part is, though, is where we had a corporate statute that outlined what had to be in your bylaws, how you performed, how we were to vote. LLCs don't do that. LLCs don't do that. There is some of that, depending on the state or the country you're dealing with in the LLC, but the idea is that you write an operating agreement. And if you don't have the right person writing the operating agreement, it can really be a mess. It's a source of tremendous litigation. We've handled a number of these matters because people think it's like doing the old bylaws. It's not. You really have to write these operating agreements properly. This is more on the LLC. As you know, the tax side of the LLC is generally a pass-through. If it's a single member, it's treated as a sole proprietor. You know, there's all kinds of issues now with that. You know, do I get a federal ID number? Do I not? I think the IRS kind of wants you to get a federal ID number if you have an employee. I think they kind of just want every single entity to have a federal ID number just to track or whatever they do. You let me know when you figure it out. But the idea is that a single member can be totally disregarded. Or it can be a corporation, and then it can elect S if it qualifies, or it can elect C. And you can post a question, by the way, to Tony, or raise your hand, and we'll take any questions during the seminar, no problem. If you have more than one owner, right, you've got the multi-member LLC, you can't be a sole proprietor. Then you become a deemed partnership, or you can elect corporate on the 8832, and then you can go S, you can file S election, or you then you would stop and you'd be a C. So it's very flexible. It's very, very flexible in that regard. There's some issues here. You know, will I become a single member? This is some of the things we're going to hit: the internal affairs doctrine, offshore issues. One thing with offshore that a lot of people miss actually, that I wanted to make sure you're aware of as CPAs. When we go offshore, it's not that you guys are going to be forming offshore, but you may see one. That election of status process completely changes. Okay, you're going to be deemed a C Corp most likely. So you got to be careful. You know, now we have the low rates, but when they go back, they're about to go back. But the idea is you may not know it, but you're a C Corp. And we've had a number of problems of people who had made their own elections, trying to work that out with the IRS. The election of status process completely changes if it's a foreign LLC. When we look at some of the LLC statutes, we try to pick and choose. Some statutes are more protective than others. We'll go through some of those protections, which in many times are related to the single member. Is a single member protected? What is multi-member? Can I be foreclosed out of equity? This type of thing. The statutes vary wildly. We've got 50 statutes, 50 states, and we deal with 2 offshore as well. The offshore are pretty good though.
I think so. Yeah.
I mean, it's clearer, you know, because we had the Americans draft those anyway. So how do we pick and choose? How do we pick and choose these statutes? What do we use? I mean, the people in Florida, CPAs are in Florida, like, oh wow, I kind of just always use Florida. I bet you guys are saying the same thing. You know, I kind of like, Lawyer always uses New York. Well, that may not be the smartest move. That may not be the smartest move. When the rubber hits the road is not when they have a business issue. If something goes wrong inside the business, the actual inside asset protection will work in either case. It's when an owner gets sued. Is the equity insulated from collection? And the different states are very, very different. So the idea here is, to get a little insight, and the little insight is the internal affairs doctrine. I want to make sure so we were like 5 minutes late, right? Yeah. So the internal affairs doctrine says, if I'm in one state, I can pick an entity in another state, and my state will respect the terms of that entity. Does it work? Depends on the judge. It's supposed to work. It's supposed to work great, but it doesn't always work. It's just you get these bad actors, and the judges go off the rails. But that's the idea. You can, if you're in New York, you can pick a Delaware. Half of Manhattan, all those entities are Delaware, because Delaware has a finer statute. And then what it impacts here is, the statutes of limitations, inside transfers, charging orders. It also impacts, can I foreclose equity? It's the single member issue. So that's the basis is the internal affairs doctrine. A lot of people say, well, doesn't the U.S. Constitution say, I can operate in any state? Not really. Not really. The U.S. Constitution does it. What it says is, if I get a judgment in one state, if I sue someone and I get a judgment and they owe me money, I can record that judgment in any other state and collect in that state. A on this choice of, we could do a whole seminar on this slide, by the way. A on the choice of law issue on this Voidable Transactions Act. I think that last 2 years ago, when we were at New York, we spent some time on this. I don't want to spend too much time, before we get to the tax side. Basically, there is a statute that talks about, if I take exposed assets and I dump them into an LLC, and I say, nanny boo boo, I've got an LLC. You can't get in to an LLC, because the statute says, look, if you sue me, you can't reach in. I'm protected. This Voidable Transactions Act said, no. If you move something away from me to avoid me, I can go get it. And that allows the plaintiff to get it either by proving that you did it on purpose. You try to move away from me to plant it in this LLC or this trust, or you can prove, look, they moved the stuff in to avoid me, and now they're insolvent, which means there's nothing else I can get. If you can prove that, even if they didn't intend it, you can go get the asset. That's a little tidbit. If you have any questions, let us know. Different seminar. Actually, on our YouTube channel, there is a seminar on voidable transactions as well. You may want to, hit that one before bedtime, because it'll put you right away. There's some pretty interesting cases, though. Anyway, so let's get into, like, what are we doing? Like, when we want to reach into an LLC, what's the best jurisdiction? How do we choose a jurisdiction? This woman here, Sabrina Barber in B. Sabrina Barber borrowed $64 million from Wells Fargo Bank. She bought all kinds of real estate. I don't know how she got 64, who knows? It was a Miami and Orlando issue. And then she defaulted. Right, that's how we get into these cases, and they sued, right, and they got a judgment. These are great, because when you sign a note and you owe someone money and you don't pay, it's like the easiest case on earth. So they get a judgment in Florida. She says, no. I funded a Delaware bank account, and I funded a Nevis LLC. Right? So if you and I were like normal people, as the judge, would say, you can't do that, Sabrina. By the way, Sabrina, she funded a Nevis LLC, but Sabrina kept all the accounts in Florida. That was her own little dingbat issue, but you know, she kind of probably deserved it. So the judge says, well, all the accounts are here, right? But doesn't say you formed that LLC to avoid Wells Fargo, so I'm going to go use the Fraudulent Transfer Act to get it. He says, let's take a harder look. He says, well, it looks like a Nevis LLC, but I think we're going to call it a Florida LLC. And Florida doesn't protect the single member LLC. These were single member LLCs. That was the end of that. So now it's a Florida nickel.
She also sold her homestead, which was a mistake.
She had a homestead, and she had and the homestead is different. You can't use the Fraudulent Transfer Act against the homestead. Someone advised her to sell her home, so she sells the home. By the way, we don't know. I don't know how much equity she had in her home already. She sells the home. She takes the money, she puts it in some cockamamie thing, and she loses all the money. Yeah. So much for that. So the judges will do whatever, you know, they want to do, essentially, in these cases where someone's just kind of basically stealing the money. So just when you see this stuff as a CPA, you'll see the issue. The issue is, if you want to use a foreign LLC or a foreign trust, do it before you have a problem and move the assets abroad. If you move the assets abroad, your U.S. court has no jurisdiction of those assets. Much harder to deal with. Related to that is this JP Morgan case. So they had a litigation in, I believe it was either Nevada or New Mexico. I think it was New Mexico. And there was a New Mexico judgment. And the judgment holder said, you've got some money in these Colorado LLCs. You know, I want that money. I have a judgment, I want that money. So instead of staying in New Mexico, so like that's what happened in Barber. So they were in Florida, it was a Nevis LLC. Florida's going to want that money. Florida doesn't care about the Nevis law. I don't know if the New Mexico judge really cared about the Colorado law. Don't know the facts, but they went to Colorado. So if you go to the jurisdiction associated with the LLC, where the LLC was formed, you're probably not going to do as well as a creditor, because the court is going to look at that statute hard and interpret it just the way it reads. The Colorado statute did not have an exception for a single member. It just says you can only get a charging order if you sue a member of an LLC, and they didn't get the money. They didn't get the money. They're in Colorado, and that's what happens when you go to the jurisdiction of the LLC. That's the issue to keep kind of in mind. So a couple other interesting cases before we get to trusts.
This is a good one.
It's a great one. You had a Maine litigation, MAINE, and the creditor said, well, there's some property, I believe there was some property in Alabama, but the LLC was in Delaware. And so the creditor goes to Alabama and says, look, I'd like to collect on my judgment, the property's here. Alabama court says, but let me just paraphrase. I don't think so. This is a Delaware LLC. You have to go to Delaware. Is that true? I don't think so. I don't think so. I think technically, if I had my way, the internal affairs doctrine would apply and you would go to Delaware law, right? But an Alabama court can interpret Delaware law. This court said, no, if you're in Alabama and you're looking at a collecting on a Delaware LLC or whatever other state, you got to go to that state. Incredibly debtor-friendly case. That's called Arroyos. Let's see here. And these are like, well, who wins? If you know who wins, guys, you let me know, because there's, I mean, essentially what you get out of these cases is you want, as a debtor, you want to be in the jurisdiction, in the court, determining your fate on collection where the LLC was formed. This is the single member LLC. And before we get to that, there's also an issue associated with certificating these LLC interests. There was a later Florida court decision that says if you certificated the interest and the certificate was not in Florida, the court would not take the interest, the equity in LLC. That then was questioned by a second court in Florida. We don't have a determinative result yet from the Florida Supreme Court. But it's the idea is you should certificate these certificates. They become mobile and they're more protected. Let's move to single member LLC, which is kind of the issue. Ashley Albright, a movie star, had a single member LLC. She went bankrupt. And then we learned what we've been saying for years about foreign trusts and bankruptcy. Do not go bankrupt if you have assets. Bankruptcy is to discharge debt. If you have assets, you have to be very careful because you have surrendered to the bankruptcy trustee. Essentially your assets, they're supposed to follow the protections of the local jurisdiction, but the reality is once you surrender, you're in a totally different situation. Ashley Albright, they said you have no partner. The charging order, this idea of only being able to get a lien on equity in an LLC came from partnerships. This is how far they'll go to get to this equity. Ashley's saying, well, it's not a partnership, it's an LLC. We're in Colorado. No, it came from partnerships. You have no partner, so it doesn't apply. We're not protecting an innocent partner, so we're taking the LLC interest. That kind of started this whole snowball effect on single member LLCs. In Florida, it's years later, outside of bankruptcy, there were several other bankruptcy cases. You cannot be a single member LLC protected in bankruptcy at this point. We went to the civil court. So we had a huckster credit card fraud guy. They just had to get to this guy. He lost, I think it was to the FTC. Yeah, it was a government claim. So as a CPA, you see the clients running into issues. If it's a government claim, if it's an IRS claim, as you know, I mean, there's just unlimited money. You want to settle this out. You don't want to fight the FTC if at all possible. He did. They closed him out, and they certified the question to the Florida Supreme Court. Can I crush him and take all of his single member LLC interests? Because it was unclear in the statute. The statute just was a generic statute that says that the equity is protected and it's only subject to charging order. To me, that says the equity is protected and only subject to charging. But okay. Bad actor again. Now we got a bad actor, and he's got a single member, and we had some bankruptcy cases that say you can take the single member. Florida Supreme Court eviscerates all protections of the LLC, essentially calls it a corporation. The legislature has to step in. They take all Olmstead stuff, has to step in to resurrect the LLC. But you know what they did? They left the single member loose. The single member is not protected in Florida. There's a standard. I mean, if you're making continuous distributions out of your single member LLC, you might have an argument that it's protected, but in general, it's an unprotected entity. I'm, saying enemy because, it's a problem, I guess. Down here. Oh, it's definitely, yeah. In New York, it's a problem too. You don't want to have a single member LLC. Nevada and Wyoming. So what happens is in the different jurisdictions that protect the single member LLC, they added a line. It's like the thing from the commercial, and that means you, Elmer, or whatever. At the end of the protection that said the equity is only subject to charging order, And that includes a single member LLC. They added this line, including the single member LLC and only a charging order, exclusively a charging order. So you want these jurisdictions that have kind of done that and put the nail in the coffin on that. And that's who you pick. When you try to use the internal affairs doctrine, you pick, if you have to go single member, you pick Nevada, you pick Delaware, you pick South Dakota. We used to use Wyoming, but Wyoming had a terrible case on veil piercing, so we don't use Wyoming anymore. And we got about, I'd say about 10 minutes to do trust. Let's see what we're doing now. This one goes back into, so do we go 99-1? Is one person a multi-member? Not according to the Albright and Olmsted courts. They would have crushed it. You know, they would have called that a single member.
Sure.
We've got a case that rules on it, more or less, called Corchi. Corchi sued Baldwin on a small debt, a relatively small debt, according to Baldwin. Baldwin is this gazillionaire who formed a number of family entities, didn't do a very good job of. I don't know, what the backdrop story was on this representation, etc. But he formed them, he funded them, I understand, with almost $1 billion. And I guess he didn't like Corchi. He just decided to default on debt to Corchi. Corchi sues. Look, I need into this LLC. There was a kind of an ugly case in Florida that says LLCs cannot be reverse pierced. That means when you foreclose equity, because there was a case that talked about corporations, and the corporation could just be taken. You don't have to reverse pierce because there is no protection of corporate equity. And so the suggestion in the case was there is no reverse piercing, but it was about a corporation, which doesn't really come up because you can just take equity in a corporation. So that was the issue. Can I take the equity in an LLC? And basically, because Baldwin had set this up as 99-1 and then had made almost $200 million in distributions previously, then all of a sudden decided not to make distributions to the lien holder, the trial court says, no, we've got this case. It says you can't reverse veil pierce. Corchi appeals the case, and it goes up, and they're like, no. That was a corporate case. This is abuse. We didn't say that you cannot foreclose out the equity. We didn't say that in an LLC. And the suggestion was 99-1 is not going to cut it. 1% to the wife is not going to cut it. No mention of the fact that it was a Delaware entity. Delaware has that language that says even if you're a single member, it's protected. And that was that. Don't know what happened at the trial court. I don't think that's been published. So you got to be very careful with this 99-1 stuff. We typically want to use the tenancy by the entireties. If you're in Delaware, we want to add the kids, or if they're young, we want to add trust for the kids. And then, there's other courts that have said, no, there is no reverse veil pierce. Offshore, I'll whip through here because I want to talk about trust for 10 or 15 minutes. I drafted a portion of this statute in Nevis. It was adopted, I think it was in 15 actually, and then they had a new statute in 17. It's very protective. It's basically modeled on the Delaware statute, and the fraudulent transfer and charging order rights are very limited. It's a very, very creditor protected entity. Works great under a foreign trust. This is a rehash of the Wells Fargo case where we want to be very careful to pick the right LLC and do it before the clouds have formed. This basically going through the fact that the Florida court called the Nevis LLC, a Florida LLC, we want to have the assets offshore. I like to have a manager offshore. We can cap it with a trust, which has a foreign trustee, much more protective. Let's get it out of the jurisdiction of the US. And these are the keys to success, which are basically picking the right entity, doing it before you have problems. And these are some of the statutory protections: absolute prohibition on transfer, no dissolution, no foreclosure rights. And this is a similar issue with branch banking and trust, kind of a funny case where someone didn't have good documentation, and funny for us. And it was in front of a federal magistrate who started reading sunbiz.org. That's our public filings, and went by the and started moving around assets and equity based on the public filings. They did get it appealed. They showed that the operating agreements were correct, and they got it reversed. You just have to be very careful with properly papering what you have. I want to spend 10 or 15 minutes on trusts. New York has a number of trust statutes and a great probate code, really. Same in Florida. You can have revocable trust, special purpose trust. I had mentioned that trust, historically, you form a trust, you divide title for the trust. The trustee controls it, the beneficiary benefits. If someone sues the beneficiary, nothing to get. Nothing to get. If the trustee controls it, they're not going to make a distribution out. Now we have asset protection trusts, which you've probably heard this term. You can form a trust for yourself, not in Florida, not in New York. You got to use one of 18 states, and typically the trustee must be in that state. What we want to do is we want to create, if we do this, it's a lot of times comes down to the Albright Olmsted issue. If we have someone that has to be a single member and we can't add anybody, so we can't protect that LLC equity, we might put their equity in a trust that they form for themselves. Let me know if you have any questions on that. So if you have someone that can't protect LLC equity, maybe we drop it into a U.S. asset protection trust that they form for themselves in a very strong jurisdiction. They're self-settled. England didn't allow for that for 500 years. Offshore, you can do it. A lot of money was going offshore. And so Alaska, Nevada, Delaware, they said, look, we'd like some of that money that's going offshore. Let's make it so people can form their own. The problem is it's largely untested. And you can't go bankrupt. Huber, this first case, he went bankrupt, and he had although he had it was Alaska, he had an Alaska trustee. His co-trustee was in state of Washington. The money was in the state of Washington. You know, he never left the state of Washington, blah, blah, blah. He goes bankrupt in the state of Washington. They say, you're in the state of Washington. What are we going to do? We're going to call it a Washington trust. Can't form your own trust in Washington. It's unprotected. So we want to create, this is bankruptcy. You wouldn't do that if you had any brain in your skull. But in any case, you would create a link. You'd have, if you did Nevada, we kind of like Nevada, you would have a Nevada trustee. You might have your account, if you're in a wire, house account, at least one in Nevada. We have clients, very wealthy clients, that have bought residence in Nevada because they want to create the protection, the connection to that jurisdiction that Huber didn't have. Mortensen was the mountain man who thought he had it all figured out. So he creates a homemade, which might have been helpful, which might have worked, the homemade asset protection trust. And then he waits a few years, which was good, which was smart. And then he gets a divorce. The period by which you can claim that someone funds a trust on a fraudulent transfer, is either 4 years or 2 years, depending on the jurisdiction. It had passed. The period had passed. So the wife legally was going to have a lot of trouble getting into that trust because you couldn't say it's a fraudulent transfer. You knew you were going to divorce, so you put it in trust. The time had passed for her to claim that. So he makes it easier for her by claiming bankruptcy, which opens up a 10-year statute of limitations, and she comes into bankruptcy and takes all the stuff. Absolutely crazy case. Some of these statutes you have to keep in mind require some specificity, some very specific filing requirements, some affidavits, whatever it is financially that you have to file, you should do it, because if they come under attack, that's what they're going to attack. There's some kind of technical
Formalities are very important.
technical issue. Trustco v. Matthews. Fortunately, in this case, Trustco did not really understand the collection, in my opinion, understand the collection side of this. Basically, Trustco got a judgment in Florida. The client, though, had told Trustco that it had done some estate and trust work and had funded this trust several years before. And then the plaintiff sued for collection in Delaware. Now we've got a Delaware court looking at a Delaware entity, and they actually punted and said time period passed for fraudulent transfer. We don't even have to rule on whether or not this is a protective entity. You can't claim fraudulent transfer because the period of limitations has passed. Kilker v. Stillman. This was basically a pool contractor who years after the statute had passed had gotten sued on a development that went bad, and got too cocky, was kind of nasty with the judge and said, I've got an asset protection trust, and they took it anyway. They kind of took it anyway. You don't want to get too cocky. This may be an outlier case. It is law in California if you go there. But is that going to happen in every state? No, we don't want to. You never want to get too aggressive with these asset protection trusts because they are somewhat new. Foreign trusts are unbelievably protective. We mentioned full faith and credit here. That was where you can take a judgment in one state and register it in another state. Well, that's not true offshore. So if you have your assets offshore inside a foreign trust, there's no jurisdiction of the U.S. court. If you're a bad actor, they'll try to do a civil contempt action against you, but that's very difficult. That's why they put you in jail. Very, very difficult. It's happened a couple of times with bad actors. Typically, you've got a government plaintiff that's got unlimited funds in those cases.
But it's still limited in these folks.
It's very limited. They have to let them out of jail. You can't hold someone forever in jail. One guy did manage to stay in jail for 6 years. Other than that, it's 6 months was the record.
He kept the money though.
He did. He kept the money. Yeah. So here are some factors associated with foreign trusts. You definitely want to keep the assets out of the U.S. This is that Sargent case where you want to have your LLC certificated. So if you need to move them out of the country, it's a defensive move. You want to follow your formalities and pretty much work on what I make out of this slide. Basically, also be diverse. Be diverse. You know, if you've got a very wealthy client, don't put everything in a foreign trust. You know, we have people that do these foreign trusts around the country, and they say put everything in the. I wouldn't put everything in foreign trust. We would structure an estate plan, and as part of the estate plan, we would create an LLC holder. Most likely, we may have a domestic asset protection trust, create a little extra protection. We may have a piece in a foreign trust, especially if there's a business sale, there's a big indemnity obligation. You may want to protect what you have in a foreign trust, at least during the indemnity period. And then you have this kind of Andromeda strain where when you get into the default on the note or the indemnity litigation, you slide over the structure and they have to hire someone like us to figure it out. That's what it kind of comes down to. This is a foreign jurisdiction chart, which shows some of the characteristics of the foreign jurisdictions where it's hard to prove fraudulent transfer, the charging order expires, etc. This is just a general idea. We want to have a separate trustee. We want to have it managed properly. we don't want to use these trusts as a piggy bank. If you have a client that wants to constantly reach into the trust, just let the client have a bank account on the side with whatever they need in terms of day-to-day cash. And here's some of these keys to the effectiveness, and basically what they come down to. Okay, that's perfect. What they come down to is create a connection to the foreign trust, and don't be abusive. Don't go bankrupt. All right, well, Brian's going to present the tax side now, which of course is very relevant to the CPA side. It's quite a bit of material, so if you have any questions, let us know.
Yeah.
Okay, we're good to resume.
Okay.
You can proceed.
Thank you. This is a very broad overview of these areas. I mean, you know, a lot of these areas could be just a seminar in and of itself, just the compliance by itself. But we wanted to give you all some broad strokes of what to be aware of when you're utilizing both domestic and foreign trust, and the different types of taxes and how they affect the creation and funding of these entities, which we've been talking
That's
about.
right. Brian's going to start you from the basics and then try to get you through compliance.
Right. So just from a basic standpoint, which I'm sure you already know this, but you know, there are these different types of taxes that will apply to wealth, and you know, going into a trust, depending on if it's done either at death or during life with an inter vivos gift. That these 4 areas you need to be aware of, and how you know the effect on the transfer. They're called transfer taxes. Obviously, we have the federal estate tax. You know, that's been around for a long time. I guess since, you know, from early on. It's right now, you know, the exemption amount is 11.7 million per individual under the law we have today. It's likely to go down, but that's what it is right now. So basically, anything that is owned by someone that dies at death and it passes to someone else, it's part of their federal gross estate, and it potentially is subject to tax after you apply the credit or whatever it is. And so that only happens at death. The gift tax is for transfers that take place during someone's lifetime, an inter vivos one. Right now, the credits are unified and they're combined. There's been discussions recently to decouple them, which I know that some states, when it comes to their estate tax, it's been decoupled for a while. But now they're discussing like it was back in the 1970s, where
I think for a while it was decoupled.
It was
like in the what was it, 03 or 04? When it was $1 million.
Maybe.
Yeah.
That was before my time.
Oh, it was before your time. I'm so damn old. I forgot.
At least I'm all. I'm only gonna hear about the taxes.
Okay.
But anyway,
it was decoupled. So you have to be careful, because if they say the gift exemption is $1 million, but the estate exemption is $5 million, you know, it sounds great, but you can't get it out of your estate while you're alive.
Right. So I mean, you know, so there's been discussions I've seen where now they're talking about making it at 1 million during life, and then perhaps 3.5 at death. We'll see what happens. But you know, obviously that's at the federal side. And of course, if you have something that skips a generation, there's an extra tax, because back in the 80s, the extremely wealthy were able to make distributions or transfers to their grandkids or great grandkids. And then the wealthy were like, that's not fair. We don't have the money to do that. You should be taxed twice. So they came up with this other tax that exists if you're a skip person, which is 1 generation below the kids, or if you're 37 and a half years younger than the person that makes the transfer, if you're not a family. The amount right now of the credit's the same, 11.7 million. It's easy right now because they're all the same, but that could change. And then lastly, I know in the state of New York, historically, inheritance or estate taxes at the state level, that's something you need to be aware of as well, which I'm sure you all are. But those are the, you know, we don't have that here. Everybody moves down here. That's why we're the burial ground of the East Coast. But you know, everybody comes down here. But that is a broad like an overview of things, and this is important because when you start to utilize these entities, you need to understand that, you know, the effects on taxes, what happens when you fund them. So, on a basic level, on the domestic side, the income taxation is governed by subchapter J of the code. And that's under Title A of income taxes. There's basic rules. simple and complex and trust. I'm not going to go through all these because you guys know you know the rules. It's important though. The accumulation tax, the throwback rules are important, especially for a foreign trust. We'll get into that. And then of course the granted trust rules are also very important for a U.S. owner of a foreign trust, and we'll explain why. Has to do with the deemed sale thing that we have in the income tax code that is irrelevant to the estate and gift, but we'll get into that. Okay. Basically, as you all know, Form 1041 is your friend. When you have a domestic trust, it's filed annually, and they have, a tiered rate structure. As you know, it's very compressed for a trust because Congress has decided that they don't want trusts accumulating money without paying a higher tax. So they want you to push it out. That's why it's designed like that. And that conduit, that K1 that comes out each year, which is great for a simple trust, but when you have a complex one, or you don't want your kids or your grandkids or whatever, or a client doesn't to get money, they're going to accumulate those funds in the trust, and the trust is going to pay a higher tax. It's just the way it is.
So if it is distributed, the trust passes the income out, and then the distributee pays at their rates, is
Right.
what Brian's saying. So you want to try to avoid trust income if you can.
If you can.
Yeah.
You can. Sometimes you can't. So, okay. And just the basic rules, if you don't know this already, a simple trust is really easy. You just have an informational return each year until it basically terminates, and these rules have to apply. All three do for it to apply, which is one, all the FAI has to be distributed out in a tax year. You can't give any charitable distributions, and you can't distribute any corpus. Those three things apply. Simple trust. If they fail any or all of those tests, it's a complex trust with a tiered distribution system. So those are the basic rules. And since they wrote these rules back in 1954, as you can see, these awesome amounts we have for exemptions, $300 and $100. I guess at one time that was a lot of money, but they haven't updated those or indexed them. So
It's been a while since that was.
It's been a while. So anyway, to be aware of that. It's pretty fun. Okay. This just goes into why and how, how the distributions work, and the deductions, and under 651 of the code. It's really easy and straightforward. The most common form of this would be a marital trust, or a qualified terminal interest trust. In the old days, if you have a second or third spouse, you give them income for life, but then when they die, it goes to the kids of the first marriage. That's what it was designed for originally, and it's still there. It's not really utilized as much anymore, but it's still there if you want it. That's the most common one for a simple trust. Okay. This is where the majority of trusts are complex, because you want to be able to sprinkle trust. You don't want mandatory distributions, especially if you have a spendthrift clause in the trust. So this is where the majority of trust income tax returns are going to be on this side. 661 is the part of the code, and if they push the money out, it maintains its character and it goes out on the K1, and the beneficiaries would pay it at their rate. If it's retained, the trust pays the tax. However, if you don't distribute, if the trustee doesn't distribute out all the FAI in a given year, and then the next year they exceed that, so the distribution exceeds the FAI, then you're going to have the accumulation tax from the income that was held back in the past. So that's under 667.
It's a throw-up rule.
Yeah, throwback rule. Anyway.
What do they call it? The throw-up rule.
Throw-up rule. Yeah, we know. It's so funny. You have these discussions, and you see some accountants' eyes get really big because they realize that they missed this, or it's not there,
Yeah.
So anyway, it's there. Just need to be aware of it. Okay, it's important though on the foreign side, and we'll explain why. Okay, so basics. Now we know how trusts are taxed. Now we can talk about U.S. persons. Obviously, we have an income tax, which is subtitle A, and we have a transfer tax or estate tax, which is subtitle B. It's important though, because all U.S. persons are taxed on their worldwide income on the income side, and their worldwide assets on the estate side, estate and gift side. That's important because if you have a foreign trust, it's likely to be a foreign entity, so it's offshore. So these rules that we normally would utilize for an individual in the United States or an entity in the United States won't necessarily apply. So you know what they are. And income tax is pretty straightforward. Either you're a citizen, or you're a green card holder, or you meet this substantial presence test.
Mhm.
That's it. On the estate side, estate and gift side, it's where you're domiciled. Now, what does that mean? It's where you physically reside, and you have to have intent to remain.
Well, you enter with intent to remain, right? Yeah.
Right. But as you see, they can be different. So you might have an individual who is a U.S. income tax resident, but not for estate and gift, and vice versa.
So you have to keep that in mind. It's a very, very good planning issue. So even if you have a client who's working in the US, you may have the ability, even though they're a US income tax payer, based upon the fact that they're subject to tax on their worldwide income, they can move assets around because they don't plan to stay here forever. It's either obvious or they, that's the return ticket deal. Everyone's got a return ticket. But, it could just be someone, an executive here on a contract for a period of, Swiss guys here for 3 years going back. Everyone knows he's going back. Well, you may have some ability to plan based on the fact that he's not a U.S. domiciliary. He is not a U.S. resident for estate and gift tax purposes. He's going to have some interesting opportunities. Same is true. You could even be a domiciliary, but you're not a U.S. income tax resident. You can buy and sell securities not involving real estate at no capital gains. So there's some real planning there when it comes up. We like getting questions from CPAs. Don't worry, just call us anytime. That's how we get business.
So that's for the folks on the U.S. side, but for a non-resident alien or a non-U.S. person, foreign entities, including foreign trust, the rules are obviously going to be a lot different. Number one of which is, non-U.S. persons are only subject to certain income tax from the U.S. income, depending on the nature of the asset. One of the big exceptions are stock sales. I mean, that's a huge thing. We want to encourage investment from people on the outside of the United States, so you can buy the stock, you can sell the stock, not pay any income tax if you're the non-resident alien.
Capital gains.
Yeah, or you can also gift it.
Mm-hmm.
And there's no U.S. gift tax issue with that. You just don't want to die with it in your individual name.
Yeah. So you just crossed over, right?
Right,
So that's the idea. That's the idea. So you have income tax. You buy and sell stock, securities unrelated to real estate, no tax. And then that's your exemption, and then as you're going to see as we get into the gift and estate stuff, that same intangible can be gifted at no gift tax.
Right. And that includes to a U.S. person that's here.
That's right.
So something to keep in mind. So that's, so one exception to income tax are the stock sales. I cite the code there. We also have the effective treaties on the income side. And that just depends on the facts, depending on if we have a treaty or not, and what those benefits are. With passive income, there's a 30% withholding rule, the 1042-S, obviously, and that's something you need to be aware of. And then if it's effectively connected to income, it's graduated. It's tiered depending on the income level and the type of industry it is. Now, from the foreign trust side, a foreign trust will not pay U.S. income tax, the entity itself, unless it has ECI gain or it has real estate gain.
Well, ECI, effectively connected income,
right,
to a U.S. business, right, or real estate. So it's treated as what? A foreign, kind of like a foreign
non-resident alien, right?
Non-resident alien, right? Totally non-resident.
And then for the U.S. beneficiaries of a foreign trust, they're only taxed on the income when it's available to them. So there's a distribution from the trust. So those are the rules there. On the estate side, can be very sorrowful if individuals aren't aware of this individually. We have a story here in a little bit about that. But basically, as we already said, gifts of intangibles are exempt. So if they have a U.S. stock and they gift it, no issue whatsoever.
But if you die with it, subject to estate tax.
Right. And what is the credit for a non-resident alien?
$60,000.
$60,000. That's it. That's it. And then you have treaties as well.
And no husband and wife exemption.
Right. That's right. We had a case here not too long ago. They bought that mansion down in Celebration, right?
In your Celebration. Yeah.
That's near Disney, and that was husband and wife, and one of them died unexpectedly.
And there's no husband and wife exemption. So
they were non-residents.
So it's half of the house because they did not have the foreign entity own this house, was subject to the estate tax. It was like $2 million or something. It's crazy. And with very basic planning, they could have avoided it. Very basic planning, which we'll hit on.
Right. So those are the rules on the domestic side, and all these rules are important because when a U.S. individual, which if you're going to do a foreign asset protection trust, you're going to have a U.S. owner of those assets. They're going to create a trust that benefits themselves and likely their family. It's going to be offshore. Well, it's important because when you create an international offshore foreign trust, when it's created, the facts of who the grantor is, who the beneficiary is, and how it's funded are going to affect the taxation on both the income tax side and the estate tax side. And we're going to explain why, because of the rules. This is one of the few areas in the taxing code to where, because of the policy ideas behind it, they don't necessarily reconcile with how we would think it ought to occur. And one of which is on the domestic side, if you make a gift of your assets to a domestic trust and it's irrevocable, so you're giving up all dominion and control over the asset to benefit another, you have completed the gift for U.S. transfer taxes. So you would utilize your credit. It's out, a transfer basis for your beneficiaries of the trust, and then when you die, you don't own it anymore. It's gone. It's out of your estate. On the foreign side, not only can you utilize your credit to get it out if you want to make a completed gift, but there is an income tax, a consequence to that, and we're going to explain why. Because it's basically, the idea behind it is you have expatriated that asset outside the United States.
And we do a different seminar on expatriation of people who typically pull their assets with them. And it's the same idea. You're moving things outside the jurisdiction of the IRS, and they don't like it, and they deem you to sell them. It's as if you have to incur that capital gain.
If you think about it jurisdictionally, once they leave the jurisdiction and it's offshore, for all practical purposes, that asset has been removed from the United States. So that's why they have done this. It's just that you'll see that when this occurs, it's not what a lot of individuals think when they make these entities, the income tax side, that it's there and it's totally missed.
Oh, totally.
Yeah,
we find it's totally missed. And also there's a pre-immigration issue that's totally missed. Similar.
So at the end of the day, it is, where is the trust going to be? How is it funded? And then where are the beneficiaries? And where's the trustee? All these things apply. And, it's interesting of why. And it's important because there are special rules for non-resident, aliens. And a lot of these rules, with some exceptions, apply to a foreign trust entity.
It's like a non-resident alien. Yeah.
And the key is, being a non-resident, they're not subject to things that are outside the United States. And, you know, a non-resident alien themselves, if they own U.S. property, when they die, they only get a $60,000 amount for their exemption. Okay. So what is a foreign trust? Well, from the IRS code, there are two tests. So to have a domestic trust in the United States for income taxes, they have to meet two tests. One is the court test. Does a U.S. court have authority to bind the operation? So where is the trust administered? What does it say in the trust document? The rules of this state will apply. That's the court test. Where is it? And then the control test is, where's the trustee? Are they domestic or are they offshore? So if you have both of them in the United States, you have a domestic trust. So for the run-of-the-mill trust, especially if it's a rev trust, the grantor's here, the trustee's here, and it's formed in a state, the United States. So it meets all the criteria. So it's a domestic trust on the income tax side. That's fine and well, but if a person dies and the person who's the successor trustee is their brother who lives in England, something's changed. The trustee now is offshore. And so at that point, you have a potential conversion of the trust, of a domestic trust, to a foreign trust. And that has consequences if it's not fixed within,
especially compliance.
Fixed within 9 months of death, you know. So something to keep in mind. Very, very common. We see it a lot down here because a lot of the clients we have moved here and they have family all over the world. And they've named a brother or a sister or an aunt or an uncle and they're outside the country. And not understanding these rules, once that conversion takes place, could have a problem. Now, why is it important? Well, in 679 of the code, it talks about a U.S. individual who creates a foreign trust, which was what we would think of would be a offshore offshore asset protection trust. The idea being as the U.S. owner's here, he creates a trust in Nevis, the Cook Islands, or wherever. The trustee is going to be there under the law there. He stays here. He funds it. He has U.S. beneficiaries here, usually his kids too. Under 679, this deems that transaction because the U.S. owner is alive, the deemed owner, and there's U.S. beneficiaries. This trust for income taxes is treated as a grantor trust during the lifetime of the grantor, or the earlier of no longer having a U.S. beneficiary of that trust. So during that time, the IRS says on the income tax side that you still have basically a grantor trust for income taxes.
And they use, because a lot of CPAs don't do a lot of estate, they do a lot of corporate. We may have some M&A guys on here. What we mean by grantor is that if a settlor, somebody who funds a trust, retains certain control over the trust, there's a list of items, but it's basically control over the trust assets, that for income tax purposes, this is not estate tax. For income tax purposes, the trust is disregarded. So it's as if the person owns the assets directly. And actually in these statutes, very interesting because it's somewhat I found it somewhat confusing.
Yes.
They actually call the settlor owner. They say if you're an owner of the trust, no one owns the trust, but what they mean is because of I think what they mean is because of 679, you formed a trust offshore, you have a U.S. beneficiary, right? So you have not now left, you basically, they want to treat the trust, even if you've given up control of the trust or some control or whatever the standard is at that point, yours. It's yours for income tax purposes.
Right.
And Brian's going to go through what happens in terms of the deferral on some of this stuff. But just keep in mind, because you're going to see this for sure. You're going to see someone forms a foreign trust, and it's confusing because then now the foreign trust rules go into operation. But if your grantor funds it and there's a U.S. beneficiary, it's disregarded for income tax purposes.
Right. And that's important because that is 679 is an exception to the income tax rule, which is found in 684, which is the deemed sale of the asset. So if you're a U.S. individual and you create a foreign trust with no U.S. beneficiaries, on the date of funding, you have a deemed sale of that asset for income taxes when you fund that trust, those assets on that date. And this is postponed by this 679 rule, the grantor trust rule, that it will stop that till either the death of the beneficiary. So there's no longer, or I'm sorry, there's no more U.S. beneficiary anymore. That would normally be a death, but it might be someone that leaves the country, or the grantor dies. The earlier of. When that occurs, then this 684 is going to apply. When it would include all the appreciation of those assets as well that have been inside this trust. It could be 20 years. And that's the rule on the income tax side. So regardless of estate and gift, so if you use the person that makes the transfer, if they utilize their credit and they get it out of their estate, and there's no tax on that side, this income tax rule is still going to apply because it's out of their estate. And you basically, at that point, a foreign trust owns assets. Those assets basically are deemed, they have expatriated off from the United States. So this rule is going to apply. The way you prevent that, and what we generally plan for, is when you have a U.S. owner, they put it offshore, but they don't complete the gift. And that's important because when they die, that asset's pulled back into their gross estate, they get a step up in basis. And there's no right, and there's no deemed sale. There's a sale, but there's no gain.
You have the basis step up, so the deemed sale, no gain.
No gain.
It's tricky, and these ideas spill into other areas, but the idea is you've got this grantor trust, no deemed sale. When they die, they get the step up, no gain. If you come across a situation where sometimes an immigrant who was foreign and had money in an offshore trust, or someone misfunds a foreign trust, a lot of we see actually people complete the gift. Sometimes there is a process to get the property back into the U.S. without tax, without a deemed sale, in a way that avoids deemed sale at death. So you're going to see that you've got this built-in gain in there, and they're in the U.S. They die. What am I going to do? Because they're going to have a deemed sale at death. There's a way to deal with it. Right? It's a different seminar, but it's just to be aware of the issues as a CPA.
Right. And just as I've already said, that understand this is just the income tax side. It's not the estate side. They're two different things. Now, if you have a foreign trust that's non-grantor, it's just like a foreign entity for the most part, like an NRA with its own rules. It would recognize U.S. source income that would apply. And then when it distributes out the funds to the U.S. beneficiaries, they have DNI and all those things. And if they don't distribute all in 1 year and it accumulates, there's going to be that tax, the accumulation tax, when it exceeds it the following year. You just need to be aware of that. That's missed a lot. Okay. So you have a foreign trust. What does that mean compliance-wise? Well, once it occurs, and there's a lot more compliance that the client's going to have to deal with on a yearly basis. And this is for the deemed U.S. owner, the person that made the trust, for the foreign trustee, and for the U.S. beneficiaries. They all have filing requirements every year. And for the U.S. beneficiaries especially, even if they don't receive income from the trust in a given year, they still have to do this compliance every year. So keep that in mind. The first one is Form 3520. This is for both for the U.S. grantor and for the U.S. beneficiaries. It's a long form, but they both have a section of this form that has to be filed on an annual basis.
So why don't you explain how it's kind of like a matching
Right.
form whereby you've got beneficiaries, you've got trustees, they're filing their particular portions of the form and they intentionally want to match everybody up and catch anybody who,
Right.
who, has money offshore. Even if you don't get a dividend, distribution, you'd still have to file this form.
Right. I mean, this is all, I mean, this form is an informational return for the most part. And so by filing it each year, it puts the IRS on notice that, this entity exists, that the taxation of this entity, depending on how it was formed, where the trustee is, and then where if there's a U.S. Bene, U.S. grantor, when they die, or there's no longer a U.S. beneficiary anymore because they've left the country. That's when this deemed sale will occur. So they want to have knowledge of it. So you have to let them know each year, and it's informational, and it's attached to the taxpayer's 1040 each year, including extensions. And it's important because, as we'll see in the next slide, the foreign trust itself, the foreign trustee also has to file a form, which keeps the IRS on notice. And then they issue out a U.S. owner statement and a U.S. beneficiary statement that those individuals will attach to their individual returns.
Mm-hmm.
So it all matches. It's all about matching, and, so they understand where things are and where the source of funds are. It's important. The other thing is interesting is that, gifts from a non-resident alien in a given year that exceed a certain amount are also reported, even though they're not taxed.
On this.
Yeah,
on this, yes, that's very, very commonly missed. Had an issue today. Had an immigrant, she's becoming U.S. and is going to get $2 million gift from someone in India and didn't know anything about the compliance. It was last year. I think she's going to make the deadline though. But I informed her about the 3520 requirement. There's no tax. By the way, this was like a foreign source gift to a U.S. brand new U.S. person. There's no tax, but you have to tell them.
IRS wants to know, and if you don't report it, the penalties are harsh. Okay, so we explained here both the grantors and U.S. Benes. Part 1 is for the donor / grantor or a settlor. It's pretty straightforward. Even if no distributions are made in a given year, they have to file it every single year because it's about matching. They'll also have the foreign grantor trust owner statement, which is provided by the foreign trustee on a yearly basis. You attach it all to your return. Okay. For the U.S. Bene, same thing. You will attach it, and of course, if a distribution is made and there's income, it would be a K1 as well. But this is how they match everything, and it has to be filed even if no income is distributed in a given year. Filed with their 1040. Okay. Here is the gift issue again. It's a pretty high threshold. But if you exceed a gift, if a gift exceeds that from a foreign resident to a U.S. beneficiary or a U.S. individual that's here, or I should say donee, you have to file this form. And this gives the IRS knowledge, hey, these funds came from overseas, and now they're in the U.S. and they know the source of the funds. That's the key. And if it's from an entity, it's much lower, 16,000. I think it might be 17 now, but it's very, very low. Mm-hmm. So be aware of that. From the perspective of the foreign trust itself, the foreign trustee will have to file a 3520A on a yearly basis. And this is due March the 15th. So a month before the individual return would be filed. And the reason why it's important is because they issue these statements, both the owner statement and the beneficiary statement, that the U.S. individuals will attach to their returns each year. That's why it's a month earlier. Mm-hmm. And they can request a 6-month extension. Obviously, it needs to match, so that you can match when you send stuff in. But this is very important because it's missed a lot. And it's straightforward. It basically lists for the IRS the foreign, the income in the foreign trust on a yearly basis, where the source is, if it's taxable or not, from the perspective of the U.S. And then when it is pushed out to the U.S. beneficiaries, or if it's a grant or trust, depending on what's going on, they know who to tax. That's what it's all about. And it gives a balance sheet too. So they know what's in the trust every year. So things are sold, they're bought, the IRS knows on a yearly basis. This stuff's,
Same idea.
ideas the same. Okay. The other compliance you need to be aware of is the 8938 FATCA. If individuals have foreign assets or they're deemed the owner of foreign assets, you need to be aware of these forms to let the IRS know. Again, it's another compliance thing. It's nothing to do with having to pay a tax, but it is letting them know. That's it.
And talk about onerous outcomes if you don't file that FATCA. I mean, you're New York CPAs, you're aware of this FATCA and the FinCEN.
Oh,
But wow, just forget the account, walk away.
Yeah,
it's a walk away.
Oh my gosh,
It's crazy.
We've seen things that just takes away the whole account. You just want to walk away. So the F bars as well are very important. Make sure that those are filed on a yearly basis, and that's just $10,000. That's nothing. Almost any account overseas is you're going to have this issue. So just be aware of these things on the compliance side, and kind of. I'm afraid now, I guess.
You're afraid?
If you don't know what these things are,
Sure. If you have any questions, you've got our contact information. Just let us know if you'd like one of my books, either on asset protection or estate and gift tax and the non-citizen. We'll get that right out to you. Brian and I are going to soon do a foreign trust book. And if you like case books, if you want the estate and gift tax from a case law perspective, we're now working on a classroom book. If you'd like that, we should have that in 2 or 3 months.